Okay, Soifer and I are also co-authors of an article that appeared in July in the Lewis and Clark Law Review. That article is Presidential Election Reform, a National Imperative. The article that's being published through Mitchell-Hamline is Gaping Gaps in the Independent State Legislature Doctrine History. So that's what we'll deal with primarily today. I'm going to talk about that article, which takes us from 1787 through about 1860. That will be my part. Then Avi will pick up on the forgotten provisions of Section 2 of the 14th Amendment, which is a whole separate avenue, a legal avenue to protect the rights of voters, both in presidential elections and in all other elections. And then Mike will focus in on the Reconstruction history of Alabama and the South, particularly events in 1868. He's a true expert in this field. He's been working on it for 40 years. And then, so that will end our presentations. So to jump into my piece, what we've seen in the last couple of years is pretty shocking. The attack on the Capitol, lawsuit in the Supreme Court asking to set aside popular elections and turn elections back to legislatures. And then most recently, in the gerrymandering litigation in the Supreme Court out of North Carolina, a strong claim that state courts do not have authority, essentially, to interpret their own state constitutions, interpret their laws in light of their own state constitutions in order to protect the rights of their people to vote. So where does all this come from? Well, in large part, it's based in this independent state legislature doctrine idea. And in large part, the independent state legislature doctrine idea comes from an 1892 United States Supreme Court case about the right of Michigan to change its method of presidential elections from a winner-take-all system to a district-by-district system. In that case, so that case had nothing whatsoever to do with legislatures stepping in and taking over the right of people to vote in presidential elections. However, the court took it upon itself and to wade into the whole history of presidential elections, made some broad statements and some deeply inaccurate statements going back to the Constitutional Convention and right up to almost to the time of the court's decision. It then had a broad dictum saying that not that the constitutional language meant something, but that an interpretation had been conceded to state legislatures by the practical application of the Constitution. And based on that history, it said legislatures had, quote, plenary power over elections generally. At least the broad dicta suggested that, even though the case was only about popular elections, not about legislatures coming in and taking away the right of the people to vote. So what we've done in our Mitchell-Hamline article is take that history that the Supreme Court laid out over like 5 pages, a long discussion of history that you would assume, since it's from the United States Supreme Court, was essentially accurate. And we said, is that really true? You know, the unexamined life may not be worth living. The unexamined premise should not be worth positing, especially when it threatens our democratic values. So that's what we've done in that article. And time and again, I think the Supreme Court got it wrong, or we do. And I'm going to give you at this point sort of highlights of several of what we develop in the article. Obviously, the details, as an appellate argument attorney says to the judge, Your Honor, the details are in my brief. Let me tell you what matters. So there are 4 pieces of history in particular that I'm going to dwell on. First, the Constitutional Convention. Second, the first election, 1788 and 1789. Third, the election of 1800. And fourth, the most significant assault on the idea that state legislatures should be able to appoint electors, which took place beginning in 1824 and on through 1826. So how did the Supreme Court get all four of those pieces of history wrong? It started off talking about the Constitutional Convention, saying that apparently the intent of the Constitutional Convention was to allow state legislatures to do pretty much whatever they wanted, including to appoint electors itself, either by joint convention or by separate concurrence, yada, yada, yada. Well, the Constitutional Convention never mentioned any of that. It did mention state legislatures, but only very briefly. The convention as a whole was about the initial idea that the state or that the national legislature would choose the president, uneasiness with that idea, and a variety of challenges to that idea, which were finally resolved in the Electoral College. The first two plans, the Virginia plan and the New Jersey plan, both provided for the president to be elected by the national legislature. But almost immediately, a plan, delegates who believed that the people should elect the president stepped forward and said the people should elect the president. But many delegates said that's never going to fly if you're talking about the people as a whole. And the immediate response on June 2nd, 1787, well, we could have electors. The people could elect electors in districts, and the electors could elect the president. That was right at the beginning of the Constitution. And that idea of the people electing kept coming back and back again. Later in June, Alexander Hamilton said, yeah, let's have the people elect the electors. That's the way you can have a national government that's grounded in the people. That's a truly federal form of government. It was discussed in the middle of June when the presidential selection was taken up again. It was discussed in August. There was a special committee that was formed. James Madison drafted according to observers, he drafted the language. He was in favor of the people choosing the electors. And from his notes of the Constitutional Convention, it's clear that that's what he had in mind. So where does this idea from the Supreme Court that, oh, what they actually had in mind was allowing the state legislatures to elect the electors come from? Well, there was just a flash in the pan. It was one of those ideas that came up, was discussed, and then was rejected. On July 17th, a delegate from Connecticut suggested that the state legislatures choose the electors. That was voted down pretty heavily. Whoops. Well, on June 19th, however, it came up again. This time the idea was let the state legislatures elect, but have the number of electors be limited to 4. So you'd have between 1 and 4 electors. They agreed that you would let the state legislatures elect, but they didn't decide anything about that 1 to 4 electors because it was immediately recognized that pretty soon everybody's going to have 4 electors. So what that proposal amounted to was that each state would have an equal vote in choosing the president. Well, that idea it passed in the general concept of legislatures choosing electors passed on the 19th. But on the 23rd, they took up another question of state legislatures, which is, should we let the legislatures ratify the convention? And they voted that down. They said legislatures are dominated, many are dominated by demagogues, and the demagogues are going to defeat the ratification of the convention. We don't want state legislatures anywhere near that. And then the next day, on the 24th of July, they voted down state legislatures choosing the electors, and it was never raised again through the entire convention. So this idea that there was an intent to have the legislatures elect is really completely unfounded if you have access to the full records of the convention, which people did not have until 1840. So when people were trying to figure out what the Constitution meant, they were dealing with an incomplete deck, a very incomplete deck. But that's the way it was. So I think we show it's pretty clear that the framers intended the people to elect, but the language was quite ambiguous. It doesn't say that the people shall elect. It says the state shall appoint in such manner as the legislature may direct. So what does that mean? What does the state mean? Does the state mean the people? Does the state mean the legislature? Well, it's already said the legislature. Use the legislature in the second part of the clause Anyway, it's very confusing language. It's ambiguous language. So in the first election, 1788 and into 1789, pretty much everybody knew that Washington was going to be elected president, and there was very little discussion about these issues in most legislatures, which were setting up the rules for the first election. But in two places, there was a vigorous debate, and the records of that debate are pretty significant. In Massachusetts, it was recognized that some people think that state means the people. It's a Republican form of government. The sovereign is the state. The sovereign is the people. So when the state is to do something, especially when it has to do with elections, the state means the people. But not everybody thought that by a long shot, and many people recognize that the language is actually ambiguous. So they felt that state legislatures had at least the discretion to go ahead and elect if they wanted to. But many or several of the delegates or several of the legislators said, you know, this is a Republican form of government. If there's an ambiguity, it should be resolved in favor of the people. And we have asked the federal Congress to send us amendments which confirm that rights of the people will be protected. And in fact, the amendments that were finally proposed and passed said that unenumerated rights of the people will not be denied or disparaged. So that's one concept, is that the 9th and 10th amendments that were ultimately passed by the Congress, but ratified by the nation, embody within them, at least in the views of those who first looked at this question, the idea that the rights of the people will be preserved in this electoral context. And then in New York, it was pointed out that if you allow the legislatures to elect, you're going to have senators. In New York, senators were elected to 4-year terms. You're going to have people elected 4 years ago deciding who's going to be the presidential electors, who's going to be the president, possibly. And that upsets the whole concept of Republican government. So there was strong opposition from the very beginning, but the Supreme Court said in McPherson, in this 1892 case, that there had been no opposition. Well, there was opposition on the very first day. And then in 1800, again, in the face of a Supreme Court decision that says there was no opposition, that was the rights of the people to elect was a major issue. It's one of the major issues in the 1800 election. It was a huge issue in New York State. It was a huge issue in Pennsylvania, and it was an issue elsewhere. And the divide came down to, in some ways, a fundamental difference about the concept of American democracy. Madison and Jefferson were pushing the rights of the people. And that was the Madison-Jeffersonian line throughout those electoral disputes. But another person who was a supporter of Jefferson, as it turns out, was a big proponent of letting the legislatures choose the electors. In the Constitutional Convention, he had moved that the legislatures actually choose the House of Representatives, that there be no popular election to any part of the federal government. Charles Pinckney is his name. He also gave a speech that promoted the 10th Amendment as something that proved that state legislatures could do whatever they wanted. So the big dispute in 1800 is, what does the state mean? Does the state mean the people? Does the state mean the legislatures? Pinckney said shortly after the Constitutional Convention that this idea of the people electing the representatives to the national government was theoretical nonsense. So are the founding principles of the country theoretical nonsense, or are they the foundation stone of the country? Those were the issues that were in dispute in 1800, yet the Supreme Court said in McPherson that there were no issues raised about the legitimacy of state legislatures choosing electors. And finally, from 1824 to 1826, there was a huge controversy over the question of whether state legislatures could choose the electors. The Supreme Court recognized that there were motions brought, that resolutions had been raised in 1823, had been brought in 1823 to have elections be by the people in districts. But it said simply that those were never enacted, nothing happened, and then it jumped almost over a decade further in its discussion. So it left out everything from 1824 through 1826. Yet in 1824, Thomas Hart Benton took up the charge. He took up the issues that had been raised in Massachusetts in 1788. He now had the Journal of the Convention available to him. He had Madison's declaration in 1800 that the state means the people when it comes to ratification. So we're back. The trolls are away for a little while. Anyway, thank you, all of your staff. Anyway, Thomas Hart Benton had way more information than the nation had had in the first 15 years when these issues were debated. And the Supreme Court had said in McCulloch versus Maryland in 1819 that even a usurpation, even if it's been acquiesced in for a very long time, can be raised if it affects a fundamental question of liberty, which the right of the people to vote for their representatives who are going to form the national government certainly relates to a fundamental issue of liberty, the consent of the governed. So for over 3 days period in early February, late January, early February, 1824, Benton gave this impassioned speech. He was exhausted at the end of each day. They interrupted the proceedings so that he could collect himself. On the last day, he was spitting up blood, and some people thought he was going to die. So he was really, really passionate about this. And when he finally was recovered enough so that they could take it up again in the Senate over a month later, a lot of people said, oh, he's right. You know what? That was a mistake to have had the legislatures do that. But given how long it's been going on, it's not, we can't say it's a usurpation. We can't say we're just not going to count the votes. We have to amend the Constitution. That's what some people said. Other people said it's a usurpation. If it was wrong, it was wrong. And we should write down his speech. Anybody who thinks they can answer it, they should put down their answers in the same document. And we should send that around and use that in the elections that are coming up. So the whole idea, I mean, the dynamic of that was that this is something that the people should look to and decide in the coming elections. Well, it wasn't necessary to do a constitutional amendment. It wasn't necessary to pass a law. Thomas Hart Benton had said, you know what, at least hypothetically, if you don't let the people elect, they shouldn't, the electoral votes should not be counted. And he was from Missouri. And in 1820, 1821, Missouri's electoral votes were not counted because Missouri violated fundamental rights of the people that are not enumerated, the right to settle. So that was a more than just idle thought. Almost immediately, Missouri's legislature changed their law. In other states where the issue had been pending, the law was changed. In New York, the legislature refused to change the law. And the legislators who refused to do that were just, it was an electoral bloodbath later on in 1824. So it didn't take very long before, instead of 7 states choosing by the state legislatures, there were only 2. And one of those was South Carolina. And by the early 1830s, South Carolina was the last holdout. And said the Supreme Court in 1892, there was no claim was raised. No serious issue was ever raised, at least not at the beginning. And as for later on, they quoted Justice Story, who said, able and ingenious minds have long questioned the constitutionality of legislatures choosing the electors. But Story didn't say why. He didn't say who. He didn't say anything about what Senator Benton. And then the House in 1826 heard a month and a half of testimony on this. In the committee of the whole, 475 pages of the House record. More than 50% of the House record for a month and a half was devoted to this issue and the related issue about whether or not there should be a contingent election in the House because resulting from the corrupt bargain election of 1824 and so on and so forth. So this was very, very hotly debated. And I think if you look, and we make the case in the law review article, I think if you look at what Benton's arguments were, he had really, really sound basis. I think he's basically right. On the other hand, the language was ambiguous. So what are you going to do about that? Well, Madison's journals came out in 1840, the nation itself could see what the people had, what the delegates had actually debated in 1878 or 1787. And then we had the Civil War. And then the issue came up again in South Carolina immediately after the Civil War. And with that, I'll turn it over to Avi to take the next step.
Thank you. And thank you both for allowing me to join you in all this. These are tenacious researchers, and I've learned a great deal from working with them. I also want to join in thanking the Law Review and the co-sponsors. And I want to establish my Midwestern bona fides. I went to junior high school and high school in Des Moines, Iowa. We won the state basketball championship, which was a big deal. Roosevelt High School also is the place, and we knew these folks who wore black armbands to protest or to mourn the death of all sides in the Vietnam War. And that went all the way to the Supreme Court in 1969, furthest the court has ever gone in protecting student rights. So in Des Moines, for a good time, believe it or not, it wasn't to be had all the time. In Des Moines, we would drive up to Minneapolis-St. Paul. And I'm a baseball fan, so I did some watching in that terrible old stadium. Anyway, lots of friends in the Midwest, lots of friends in Minnesota. And it's a pleasure, really a pleasure and a treat to be here. I don't know exactly why I'm here. I'm not an expert on election law, but I do try to teach constitutional law and do some research and writing about constitutional law. And my current question is kind of, can you still teach constitutional law with a straight face, given what our Supreme Court has done and what it looks like they're poised to do even next term? I hope the answer is yes, but it's getting more and more problematic. I want to talk about text and history. That's one of the things we tend to do in constitutional law. But I'm also here to learn, not only from my co-authors, but certainly from those who are speaking in the second hour and thereafter. A long time ago, more than 40 years ago, I wrote an article about election law in a symposium. And I wrote about what the court was up to in those days. And they were sort of pursuing neutrality. And I called it complacency in constitutional law in the Ohio State Law Review. And I used as a central metaphor, probably extended too far, Casablanca, the movie Casablanca. And Rick's Cafe, Rick comes to Casablanca for the waters, he says. Then he discovers, well, maybe he was misinformed. But as you may remember the great movie, he's not sure he's going to get involved. And finally, sort of happy ending.
All right, I got to go, guys. See you later.
So when should the court get involved? Well, the court should get involved not just because of what the text says. And what has just been said, and what will be said more by Mike looking at what happened in the South in Reconstruction era, is you got to pay attention to the context of the text, to the history, if you will. And the text is often ambiguous. And some of the leading scholars in constitutional law have made the point that historically the framers didn't intend to bind with their text in the same way that we tend to pretend they did. And the current Supreme Court certainly does that pretending. Substantive due process, oh, we can't have that. And therefore Dobbs, therefore no woman's right to control her own body, her own reproduction, because we know substantive due process is a bad thing. Well, sometimes it was, but sometimes it wasn't. For example, where do parental constitutional rights come from? Well, the answer is the 1920s. And the further answer is substantive due process. It was being used for bad things, striking down progressive legislation. But the reason parents have control, the court said in 1923 and 1925, was because they have a constitutional right. That's when Oregon in 25, well, the case came down in 25, had said, all public schools, no more private schools, parochial, private, they're out because we want to Americanize. And the court, I think quite rightfully, said you can't do that, but they also recognize parental rights. So if we don't believe in substantive due process, because we don't have the text, where do we go with the very active parents these days who think they have some rights to control the education of their children, and so on? How is it that we have a takings clause that applies to the states, a favorite of Justice Scalia's, as you probably all by now have learned? Well, there's no takings clause in the 14th Amendment. So how did it get there? They took some parts of the Fifth Amendment and they put them in the 14th Amendment, haec verba, as lawyers would say, same language, but they left out the takings clause. So how does it apply to the states? Since the old move, which of course is a somersault, is to say the Bill of Rights applies to the states through due process. But here's something they intentionally left out, or at least that's my hypothesis. Why did they leave it out? Because they didn't want to litigate the taking of property, otherwise known as slaves, at the immediate end of the Civil War. And how did it happen? In the 1890s, right around the time of the case we've talked about already, and we'll talk about some more. And it was a terrible court in many ways. Plessy versus Ferguson is, I suppose, Exhibit A, but there are many, many other examples of complicity with racism and other such terrible things, and certainly restrictions on the vote in the 1890s. So not a surprise, but in the name of due protection was the phrase they used. And they cited equity. They were doing natural justice. And that's why we have to protect railroads from states taking their property. So let's be a little bit sober about the text and what it does for us. Felix Frankfurter was not my favorite justice by any means, but he did say in a very, I think, striking way that history also has its claims. And he said that by way of explaining why he was writing a dissenting opinion rather, in the cases that led to the execution of the Rosenbergs. And he said, they've already been executed. Why am I doing this? Because history also has its claims. So the Civil War. The Civil War was the world turned upside down again. It wasn't just Yorktown. It changed things. It changed things in major ways. And one of the things that the court, I think, is responsible for and ought to be criticized for and not idealized is what they did to the civil rights provisions, the promise of the Civil Rights Act of 1866, and then as constitutionalized in the 14th Amendment. So we know about Section 1 of the 14th Amendment. Striking to me is that we know about the equality part, equal protection, but we don't know much at all about the protection part, which they intended, which is clear from the statute they were constitutionalizing just a few months later in the 14th Amendment. They knew there were people who needed protection, particularly people in the South who had been slaves. And so they meant something. And so I've been trying to develop what that protection means. There are problems of paternalism and so on. It's a complicated question. But they also knew, and that's where Section 2 comes in, that there would be some problems letting these former slaves and their supporters, black and white, vote. The South didn't like that. And so as the Southern states got reunited with the country after causing a civil war, not exactly about states' rights recognition, they said in the 14th Amendment, as ratified, perhaps not entirely voluntarily by the states, but as ratified, that if people abridge the vote, then they lose their representation in Congress. Never been invoked, should have been invoked, kind of important to think that maybe things changed after the Civil War. So once we understand that that might be true, I think we understand also that the words of the text matter. As a famous quote said, the words matter, they have a vote, but they don't have a veto. And I don't think any of the three of us is saying that they absolutely control, but what they certainly do not do is support this independent state legislature doctrine. That was not something being talked about, as was just pointed out, before the Civil War. It certainly was not what they thought right after the Civil War. Got complicated in Alabama, as Mike is going to talk about, and in Florida. But you just stand back and think about that. How could it be that the legislature really does have the authority to supersede, to preempt, to take away the popular vote for the president of the United States? How could that be? Who did that occur to? And the answer is not really many people. So we have some examples. Colorado's a new state, so maybe for one time we may have the legislature have to do something. But the basic right of the people to vote is not something that was taken away and is something that is at the base of our democracy. So this is a very, very dangerous doctrine. The immediate case is about trying to say a state court can't intervene to try to protect against just awful gerrymandering. Now, what about the vote and gerrymandering? And I will be quick about this. As much as we might have some hope, some of us, for Chief Justice Roberts, I think we should not forget that it's Chief Justice Roberts who struck down for the court in Shelby County the vital provisions of the Voting Rights Act of 1965. And I want to just develop one of the ways he did that. And there are a lot of other ways in which I think it's quite legitimate. As a doctrine, he basically says, well, it was important to have that, but it isn't important anymore. He has some statistics, and therefore it's unconstitutional? Huh? Since when does the Congress have to keep up with the changing times for it to be doing something constitutionally? I mean, just ponder what that would mean if it really were a doctrine. But here's the way he went about it. He paraphrases the 10th Amendment. So federalism winds its way through all of these discussions, or virtually all of them. And federalism is something that is not ever settled. As Faulkner once said, whoever wins, it won't be for good and it won't be for long. Federalism is very important, but as a constitutional doctrine, it's also very weaselly and very slippery. So here's what the Chief Justice and the majority did in Shelby County. Indeed, the Constitution provides that all powers not specifically granted to the federal government are reserved to the states or citizens. Okay, until you look at the 10th Amendment. He just cites the 10th Amendment at that point. Here's what the 10th Amendment says. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. So, specifically, not there. Had been in the Articles of Confederation, not in the Constitution. How did it get left out? Well, the answer is James Madison, of all people, in his nationalist phase, which certainly changed over time, helped lead the fight against putting in explicitly or specifically, because they knew the Articles had failed. That's why they were in Philadelphia that hot summer. So it's not there. And it makes a difference. And then look at the second thing that I hope leapt out at you. It says people. Our Chief Justice says citizens. There is a difference. There was a difference and there remains a difference. So sloppy, bad clerks, or planting seeds for the future. It's also our Chief Justice who decided Rucho, that said, political gerrymandering, we've had some problems with it. It's hard to find a neutral principle. Therefore, federal courts, you're out of the business. We'll leave it to state courts. Baker versus Carr, Reynolds versus Sims, which Earl Warren considered the most important moment or moments in his entire Chief Justiceship, said, political question, that's about separation of powers at the federal level and has nothing to do with states and politics in the states, which is why we got into malapportionment and the need for reapportionment and one person, one vote. That isn't even talked about in Rucho. It's just, oh, there is a right here, but we can't do anything about it. So the North Carolina case, which poses this independent state legislature doctrine, says, and the states may not be able to do anything about it either, because the legislature has spoken. So we're going to eliminate judicial review. All of this by way of connecting it to what we're now seeing, very badly needed reform of the Electoral College for sure. And we have justifiably celebrated bipartisan support for a reform bill. But both of those proposals make it conditional if the state allows the popular vote for electors. When, but not must. So as good as they are as changes, keep your eye on that. We have written in your leading newspaper that this is kind of a poison pill. And thus far, I'm not sure that many people have noticed. But if you put that in and you reflect on the election of 2020 and what people tried to do, it may be just a matter of timing and what happens when, or it may be some legislature, and we now know there are a bunch of legislatures that would like to do this, will say, well, it's up to us and we don't think the people should vote. So I'm very glad to have been invited along on this fascinating ride. These two are friends from this, even though we're co-authors. Sometimes that doesn't happen. And I hope we will become better friends as we have in the process. So thank you. And I really look forward to hearing from everyone else.
Okay. So I'm up. So I'm Mike Fitzgerald, and I am a historian of Reconstruction, and I'm not a lawyer. But the reason I'm here is that what happened in the Reconstruction South bears on this issue of what public opinion was like during the 19th century and ever since. So the issue is, what did people think of the idea of legislative choice of electors? Now, As Mark explained, at the time of the Constitution, fair numbers of states had electors chosen by legislators, but that process, that practice had gone into serious disuse by the late 20s after the contested election of Jackson versus Adams in 24, so that by the 30s, there's really only one holdout that is still having the legislature vote. And this is South Carolina. And if you know your history of the Civil War, you know South Carolina is kind of an outlier on everything. Nullification. It's the strongest secessionist state. They're the first state to secede in 1861 when Lincoln's elected. They're the guys who fire the first shot. It happens in Charleston Harbor. And so when the Civil War turns out the way it does for the White South, there's kind of a backlash against the whole idea of undemocratic behavior of slaveholders. And so as soon as the war, and so this is the place where we kind of talk about race. But let's just say that coming out of the Civil War, everything about South Carolina and extreme states' rights and undemocratic practices comes into disuse. So as soon as the war ended, the new president, by virtue of assassination, Andrew Johnson, he had always seen himself as the poor white's friend. And so he tells his guys in South Carolina, you need to get rid of this, this practice. And the government of South Carolina, the white government of South Carolina during presidential Reconstruction agrees that this is gone. So they pass ordinances saying, we must have a presidential election. And everybody thought the issue was gone because this had been the last holdout. But then something happened that brought it back into the public sphere, and that something was Reconstruction. So in 1867, after the passage of black codes and all kinds of outrages by the presidential Reconstruction racist governments, Congress steps in and says, we are restarting the process of Reconstruction, and we are doing it on the basis of equal suffrage for men. That is to say, African-American suffrage and white suffrage together in the creation of a biracial governing system. And so 10 Southern states underwent the Reconstruction process on the basis of equal voting. And by 68, most of the Southern states have redrawn constitutions. And in the case of South Carolina, they actually wrote it into the Reconstruction Constitution, and the Constitution delegates were a majority black. They just wanted to write in the Constitution, we have to have a popular vote. So it's written into the Constitution that under Reconstruction, and from now on, the people must vote for president. And that's probably where it would have stayed, except for something that really strange that happened. And the thing that made the really strange thing happen was the Ku Klux Klan. The Ku Klux Klan had been around for a year or two. I've got an admit thing. Am I admitting somebody in the waiting room? No, I'm not. Sorry, guys. Live and learn.
You're good.
Okay. So when these new states come into the Union, Congress readmits them. They figure out that they're going to have a presidential election, but suddenly they're terrified that the Klan is going to prevent their voters from voting. And there is a fear when the Democrats nominate kind of hardcore racist, that there is this fear that the Seymour Blair ticket is going to overthrow Reconstruction altogether and take away blacks' rights to vote immediately. And so what occurs to the guys in Congress is to tell their allies in places like the Deep South, why don't you just go back to the old practice and have the legislature vote right now, or set them up to vote in November. So in order to stop the Klan, radical Republicans in Congress try and get the Southern states to readopt this process. And their congressmen, the newly arrived congressmen from the South, send word home to Florida, why didn't you do this? And they do it in a couple of days. Florida legislature passes meeting, we're going to cast the vote in November, and that's exactly what they do. So Florida actually does have the legislature cast the ballot in 1868 for Grant, the Republican candidate. And a couple days later, Alabama gets in line to do it just real quickly. Only the lapse of time of a couple days gives the Northern press time enough to percolate this. They're calling off presidential elections in the states that we just readmitted. And the Democrats are up in arms. Democrats are furious. The Democrats, of course, they're horrified. But after a couple of days, the New York Times, which is a moderate Republican newspaper, says, this may be constitutional, but you know, it's a really bad idea. And after a couple of days, the radical Republican press, the leading newspaper in the country, the New York Tribune, Horace Greeley's New York Tribune, he says, you know, this is unconstitutional. No, this may be constitutional, but it's a terrible idea because it violates everything we're trying to achieve. And within a few days, you know, Chicago Tribune and a whole bunch of other northern Republican newspapers say, we hate the Klan. We think Black people should vote. We want to protect their right to vote. But you don't take away everybody's right to vote to protect them. And so the governor of Alabama, who's kind of a moderate white, Governor Smith, who's probably the most moderate conservative Republican in the South, decides to veto the bill. And he is awarded with acclaim nationwide. Democrats and Republicans just think that this is a triumph for democracy. Except that something happens to keep this issue before the public for another few months, or another couple of months. Because the radical Republicans in the Alabama legislature that had voted to have they had already passed a bill allowing the legislature to cast the ballot in November, governor vetoes it, and they're furious with the governor. The governor has made them out to be extremists. The governor has made them out to be crazies. And what they do is, it turns out there's a technicality in the Constitution that there has to be an oath that every voter has to agree not to murder their opponents or violate their civil rights. And that the voters have to take an oath for that. And the legislature hasn't authorized that oath yet, hasn't implemented that. And so the legislature, just infuriate the governor, just adjourns and goes home, which puts the whole November election in Alabama up for grabs. Nobody knows what's going to happen if Alabama refuses to have this oath. So a month goes by, and the governor realizes that he can't really call an election, and nobody on his side is going to go vote if there's no, if it's not guaranteed that there's going to be an election. So what happens is that he calls the legislature back into session. The governor calls the legislature back into session, and they refuse to authorize the bill that they want, and they don't they go on, and they essentially say that we are not going to authorize an election unless the president sends more troops, and we're going to go to Washington and confront the president and tell him this. And Mr. Governor, will you come with? And so they all march on Washington. They all show up at the governor's office, president's office. And the president, Andrew Johnson, who is the country's leading white supremacist president, probably, is confronted with this choice. And after heated debates, he agrees to send more troops to Alabama and agrees that the order will be that they will repress the Klan. And so that November, Alabama, the freedmen go to the polls risking their lives with some protection by the government, the army. And they win the state by 4,000 votes, and Grant carries the presidency. And this may well have been the reason why they win by 4,000 and the Democrats in the next state over, that in Georgia they lose by 40,000, and by Louisiana they lose by 45,000. So Alabama actually carries the state for Grant. And the story might have ended there. But here's what happens next. So Congress comes back into session, the lame duck Congress. And the president says, you should really pass a constitutional amendment preventing this kind of thing from happening again and guaranteeing people's right to vote. And the president does that. And as Congress goes into session, they're really debating the 15th Amendment guaranteeing equal suffrage. But what ends up happening is that as the 15th Amendment is being debated, a Democratic Senator, Charles Buckelew, who's kind of an extremist, has this pet project of proportional representation. And he sort of figures that if they could write the right to vote into the Constitution, it'll probably help with proportional representation. And some of the Republicans line in behind this that, it's probably a good idea after this has happened in Alabama and Florida, that we never have this happen again. And so the Senate, in the middle of an all-night session, connects the 15th Amendment, which eventually passes, with a 16th Amendment. And the Senate approves them both, which insists that the people have to have a right to vote for president. And they got it passed, they got the 2/3 in the Senate, but then there was some unrelated blow up over Georgia to where they had to scramble just to even pass the 15th Amendment. So it never passed, but it gives you a crystal clear sense that no one opposed this in principle. No one argued that people shouldn't have the right to vote. They just wondered about the expediency of it relative to the 15th Amendment. So once this crisis was over, people kind of forgot about the issue because it didn't come up again for 150 years. And so ever since Reconstruction, this issue has been totally settled. No one publicly kind of went forward with the idea that you can have state legislatures elect presidents or elect electors. In fact, this had really been settled since the 1820s. This had been really settled, except for South Carolina, for 2 freaking centuries. And so I just want you, good lawyers, to know that there is an issue of popular perception, a sense that the people have an understanding of the Constitution. And part of that for almost 2 centuries is that people and not the legislatures need to vote for president or for presidential electors. And that's all I have to say, but I'm happy to take questions as one historian among 60 lawyers.
In this rather confused state, I would suggest, Jesse, if you're ready, would you want to take some time and give us your thoughts, anything you prepared or any reactions you have to what you've heard over the past hour?
Sure. I'm actually really, I've been fascinated to listen to particularly Mike's presentation on the history around the war and Reconstruction. I'm still, I feel like I've read these stories so many times and I'm still learning new things every time. And so that's been great. And also to get a chance to look through, Mark, the paper that is going to be published this winter. You and I have been discussing these matters going back a couple of years now. And I will say, when I wrote this book, I got the deal to write this book back in 2018. And that was, less than 2 years after Donald Trump had won the Electoral College while losing the popular vote. And I think so that the question of Electoral College and fairness and majority rule was still very much at the center of the public debate, arguably much more so than it had been after the last time it happened in 2000, when I think many factors, including September 11th attacks, sort of relegated the debate over how we choose our president to the background. So it was still a really hot issue, and I think it remains so. I think, my book was finished in late 2019. It came out in March of 2020, and an unfortunate timing. It was the middle of March, and normally nothing much is going on then, but unfortunately the world was shutting down at that moment, and so it was not the ideal time to try to attract public attention to a previously arcane point of election law. But nevertheless, I think I was I was as, you know, you might call me naive, but I think even as late as early 2020, my mind was still in an older mindset of how people thought about elections, how people thought about majority rule, what states would try to do versus not try to do. And I think what happened over the following 9 to 12 months really shook me and shocked me. And I think it has led me to sort of reconsider a lot of these conversations that we have about what are the limits of our constitutional interpretation? How do people think about what it means to choose a leader? What are people willing to tolerate? You know, I think there's a story that I was not able to include in the book about Birch Bayh, who, as many of you know, the senator from Indiana who spearheaded the most, the closest effort we've ever had to replacing the Electoral College with a national popular vote in the late 1960s. And it was a story that I was told by one of his contemporaries and colleagues at the time, which was that in 2000, Birch Bayh, this was about October of 2000, this was a few weeks before the election. Now, those of you who remember the conversation that was happening around then, remember that, in fact, there was quite a lot of chatter in the mainstream press and all over the country about the possibility of a split election, our first split election in, at that point, I think it was 112 years. But of course, the fear was that it would happen where George W. Bush, the Texas governor, would win the majority, would win the popular vote, and Al Gore would win the Electoral College. So there's reasons for why people believe that, but that's not so important right now. The point was that Birch Bayh was visiting a Georgetown Law School class that was being taught by this friend of his, and the friend asked him in the course of their conversation before the students, what happens? You know, what happens if the popular vote goes one way, the Electoral College goes the other? You know, nobody's, you know, will people accept this? And you know, here's the man, Birch Bayh, who's maybe the greatest advocate in congressional history for popular vote, and had come closer and more heartbreakingly close than anyone in history. And he says, you know, essentially, I think in the end, the people will accept the system of government that we have, and they will accept the outcome. And he began to cry. And I think what struck me about that was this sort of deep understanding that there is an inertia here, and that there is that there is this kind of this desire for things to work out right, for people to be willing to accept the systems that that have been put in place or that they believe are in place. And so I think I thought about that when we saw what happened in 2020, and we saw how many you know, how many efforts were being made around the country, these shocking efforts by Donald Trump and his allies to overturn elections in the individual states. But the other thing I thought that I wanted to just flag, because I just can't stop thinking about it, is even despite all of those efforts, and even despite the attempt to undermine the will of the people in both the country, of course, but even in these key swing states where we now know these efforts were undertaken, is that the fundamental argument that they were making was a majoritarian argument. It was, we won more votes, right? It wasn't an attempt to justify minority rule. It wasn't an attempt to even say the Electoral College is a good thing. It was an attempt to say, remember this, remember what Donald Trump said to Brad Raffensperger in Georgia, find me 11,780 votes. Why? Because that was one vote more than Joe Biden had won. It was just this perfect illustration of the fundamental majoritarian bias that we all have, right? Which is, The person who gets more votes should win. And I can't stop thinking about that moment, because I realized, oh yeah, this really is where everybody's heart is. And all these arguments that we have about what can state legislatures do, and is the electoral college good or bad, it's all kind of right. It's all conditional. It's all circumstantial. And we're in this position of having to defend something, or I'm in this position, and Alex and others, of advocating for something that everyone already believes in. And it's a strange position to be in. John Koza has been doing this for far longer than I have, and I would love to hear his thoughts about it. But I think about this constantly, where the overwhelming majority of the people want a majoritarian system for choosing the president. And yet we get into these tangled arguments over how exactly the votes are allocated, the winner take all rule, which warps all of these debates, right? Independent state legislature doctrine kind of becomes much less meaningful if you don't have winner take all. So I would love, I would love to hear specifically from John and from Alex about this point, which is the fundamental kind of almost intrinsic human bias in favor of majoritarian majority rule in choosing leaders.
To John, you've been at this for more than 17 years. I'm sure you worked at it before you published your book in first book in 2005. So, what do you think?
Well, first of all, thank you, Mark and Mike and Hamline, for inviting me here today. Mark did ask me to briefly go over the reasons for having a national popular vote and how the National Popular Vote Compact worked, and the status of the legislation in the states to get the compact adopted. But then I'd be happy to toss in thoughts in answer to your questions in reaction to the presentation that Mark and Mike and Alex made in the first hour. So let me take the first part first, which is what are the shortcomings of the current system? Why is there a problem that we're sitting here discussing? And we believe there's 8 shortcomings in the current system of electing the president. The first and most obvious is that there's no guarantee that the candidate who gets the most votes nationwide will become president. And in particular, 5 of our 45 presidents have come into office without having won the most popular votes nationwide. But there have also been a lot of near misses just this century in the 6 elections that we've had. There have been 2 near misses. In 2004, when George W. Bush was ahead by 3 million votes in the national popular vote, everything really depended on Ohio, where he was ahead 120,000 votes. And those 120,000 votes were far more important than the 3 million votes that he was ahead nationwide. And although it's not talked about very much for some reason, the same thing happened in 2020. There's only 40,000 votes that it was Biden's lead of 40,000 votes in 3 states that made him president, not the 7 million votes lead that he had nationwide. So his lead in Arizona of 10,000 and of 12,000 or so in Georgia and 20,000 in Wisconsin, those were the crucial votes. And in fact, if you go back, there have been 13 elections, presidential elections, where since 1824, where the shift of a very small number of votes in 1, 2, or 3 states would have elected someone else. So we have a system that's not only produces wrong winners, but comes very close to producing them very often. The second problem with the current system, and I personally think is the biggest problem, is that that leaves 3/4 of the country out of the process. We have 50 states. When you divide 158 million votes into 50 separate buckets, just by necessity, a great many of those states are going to be safely Republican, and a great many are going to be safely Democratic. And we know from actually looking at how real candidates campaign, that if there's not a split of somewhere between ±3 points or ±4 points, presidential candidates pay no attention to a state. So the result is that, say in the last 6 elections this century, only a dozen states or so have mattered in presidential elections. All the other states are outside of that 8% band of ±4, which you will notice, by the way, is the margin of error in the typical 800 vote survey that's taken. So basically, unless your state is inside the margin of error.
John, go back about a couple lines. You were blocked, or it was frozen. You were frozen about 2 or 3 sentences worth.
Okay, I was making the point that unless a state is within about an ±4%, an 8% band, presidential candidates pay no attention
Right.
to the state, because there's no realistic chance that in the short campaign that they're going to be able to make a Wyoming go Democratic or a Vermont go Republican. And I was also commenting that that ±4% is actually the margin of error in the typical 800-person national poll. So basically, unless a state is within the margin of error, which is to say nobody knows for sure exactly which way it'll come down, it's going to be ignored. And the result is that the presidential candidates ignore most of the states. And in fact, between 91 and 100% of the general election campaign visits are only in a dozen states. So that's a major problem. And while those states change slowly, 41 states have voted the same way for the last 6 elections. So you have a very gradual change in these battleground states, but basically they are quite persistent. And by the way, this problem percolates into governance, because if you're a sitting president, you're contemplating your reelection, or you're trying to organize the election of your preferred successor. So this same process of catering to the issues that win you votes in battleground states carries through during the first term and second term of any president. And by the way, it percolates through all kinds of other things. Travel, presidential travel, particularly in their first term, is highly skewed in favor of the battleground states, etc. The third problem with the current system is that every vote's not equal, the title of our book. You have the obvious problem of the senatorial electors, and that introduces about a 1.7 to 1 disparity in the value, or pardon me, a 3.7 to 1 disparity in the value of the votes. But there's many other disparities lurking in the current system. For example, the number of electoral votes is keyed to the apportionment of House seats. And that's actually a very rough process. If we had 100,000 House seats, it wouldn't be. But when you only have 435 House seats, that process leads to significant inequalities amounting to 1.7 to 1. And then we have another more subtle problem, which is because there's a census only 10 years, the allocation of electoral votes is 2, 4, 6, 8, or 10 years out of date. And that leads to a 1.4 to 1 disparity, because many states are fast growing or slow growing. Then there's voter turnout differences. Now that's connected to being a battleground state or not, but the fact is it's a 1.7 to 1 disparity, simply because if other people in your state aren't voting, your vote is more important, and other people vote shouldn't affect your vote. And then there's the biggie, which is the disparity in the actual impact of a vote. Now, remember I mentioned George W. Bush. He had a margin of 120,000 in Ohio and a 3 million national margin. And Biden had a 40,000 vote margin in 3 states, but a 7 million national popular vote margin. If you go down and do the arithmetic, there's a 200 to 1 difference in the value of a vote in the Wisconsin, Georgia, Arizona to the rest of the country. And that's significant. So now the fourth problem that we don't like about the current system is voter turnout. So it's 11% higher in battleground states. Why is that? Because voters have figured out that their vote doesn't matter if they're sitting in Wyoming or Rhode Island or what have you. And then there's the fifth problem, which is what I call the hijacking of votes. So when you look at the votes of consistently 45% of Americans show up in the tally that counts, which is the meeting of the Electoral College in mid-December, on the side of the candidate they didn't vote for. So 68 million voters in 2020 showed up in the Electoral College represented by a elector representing the presidential candidate they didn't vote for. And then we get into another problem, the sixth problem, which is we could have an election thrown into the US House where every state would have 1 vote. And every close election, and certainly every one this century, there has been a very plausible argument and articles written about it, showing that we could have a 269 to 269 tie. And then you would have an election where each state has 1 vote. If the state's House delegation is evenly divided, the state loses its vote, but still a majority of 26 is required to elect. And if you don't get 26 votes, then the vice president chosen by the Senate becomes the acting president until the House gets around to figuring out if they can give 26 votes to somebody. So you would have a tentative acting president sort of held hostage to these House delegations. Now, what I find most perplexing is the randomness of this thing. This whole system is like a slot machine. All kinds of very small random factors flip national outcomes in presidential elections. Now, there's a study from the University of Texas that showed that there was approximately a 1% shift in favor of the Republican Party in any county where it rains on election day. And it turns out there was a county in Florida where it rained on election day, and that more than accounted for George W. Bush's margin in 2000 in Florida. Similarly, there was the butterfly ballot, a mistake made by a Democratic election official who simply designed a very confusing ballot. And something like 6,000 votes at least, far more than the statewide margin, were changed by that. They went, in fact, to Pat Buchanan, who freely mentioned that there was no way he would have gotten that many votes from that particular county had it not been for this butterfly ballot. And then you have something else. Turns out the size of the House, I mentioned the apportionment of electoral votes was keyed to the size of the US House, which is set by statute. Had that number been 100 greater, Gore would have won in 2000 simply by the accident of the arithmetic. Now, these are all trivial little factors. And we all know trivial factors can often have big effects. but a good system does not build on a pile of extremely small factors controlling a very important overall event. And finally, we get to the last and most important shortcoming of the current system is it is an ongoing threat to democracy. And the reason is that an average of 287,000 votes, popular votes, has been what has determined the last 6 presidential elections. On the other hand, the national popular vote has averaged a 4.6 million vote lead for the candidate who's ahead. So what we have is a system that's very sensitive to a very small number of votes in a very few states. And as long as that happens, and by the way, it's guaranteed to happen, because remember, there's 50 states, 38 of them are already decided as red or blue. There's 12 battleground states. By definition, those are the ones within plus or minus 4% within the margin of error of a poll. Those are the states. Of those 12 states, some of them are bound to be close almost every election. That's why they're battleground states. That's why the candidates campaign there. So we have a system that has built in the ingredients for an election dispute repeatedly coming up. And of course, as we saw on January 6th, unscrupulous presidential candidates have now figured out that all they have to do is burn down the building that has the ballots in Philadelphia, or the mail truck delivering the absentee ballots in Phoenix goes off the road into the river. Any little thing that can flip these states or can be argued to be out of line can become the basis for litigation and shifting the matter into the state legislature after the election, or shifting the matter into Congress on January 6th, or shifting it into the courts. In other words, shifting it away from the people. So those are the 8 problems we see in the current system. As the old commercial used to go, there's 8 great tomatoes in that little bitty can. Those are the 8 great tomatoes and the reason why the current system is not good. The remedy, we think, obviously, is we like the independent state legislature theory in one respect. It says the state legislatures have considerable discretion on how they award their electoral votes. So based on that and the fact that states are free to use powers that they unquestionably have to contractually get together with other states, we created the National Popular Vote Interstate Compact, which would award all of the electoral votes, all the states that sign up for this contract, to the presidential candidate who gets the most popular votes in all 50 states in the District of Columbia. And this would go into effect when states having a majority of the electoral votes, which is 270 out of 538, adopt the same piece of legislation. Now, right at the moment, 15 states in the District of Columbia have enacted this into law. Those jurisdictions have 195 electoral votes. And when we get additional states to adopt this and get up to 270, this will go into effect. So what are the prospects for that? Well, there are majorities in both houses of the state legislatures in a half dozen states right now today that would vote for this. But you can't always get a bill to the floor. And as everyone who follows this knows, there's more support for this at the moment on the Democratic side than the Republican side. So that if a legislative chamber is controlled by the Republicans, as your Senate is in currently in North Dakota, in Minnesota, where the chairman of the elections committee for years has been a vigorous opponent of national popular vote, even though the House passes it, and even though your governor said he favors it, you simply can't get it to happen. Even though there are Republicans in both houses of the Minnesota legislature, who support national popular vote. So what is the solution? Well, at the moment, the solution is to wait and see if legislative control changes anywhere in November 22. And if it doesn't, we did explore doing an initiative petition in Michigan for this current election. We backed off for a number of reasons last November, but you could do an initiative petition in states like Michigan or Arizona and perhaps some others. So that's the rationale for the national popular vote. That's the quick explanation of how it works. That's the current status. And let me throw in one last comment that vaguely relates to the independent state legislature theory, which is for the last so many years, opponents for our bill have argued that national popular vote bill could come into effect, but then after election day, if the legislature didn't like the way it went, the legislature could repeal the compact and pick the electors themselves. Now, you heard that an hour ago from Mark and Mike, which is this notion that the legislature could meet after election day. Fortunately, even under the current law, the Constitution gives Congress the exclusive power to pick the day for appointing electors. And that day is what we call election day, the Tuesday after the first Monday in November. That is the only day in the 4-year period when a state, whatever state means, can appoint presidential electors, whether it's by the legislature or the people, whether by districts or winner take all or some other method. That is the only day it can happen. So this theory that the legislature could meet after election day is completely not constitutional for the very simple reason that Congress designates that single day. Okay.
John?
Now, there is a squirrely little exception having to do with earthquakes and stuff called failure to make a decision. Needless to say, in the case of the National Popular Vote Compact, the fact that the state legislature didn't like the decision the voters made is not a failure to make a decision. It's a failure to please the legislature. So legally speaking.
John, thank you. We should let Alex go, I think.
Very good. Well, I'm
But
finished.
thank you.
Thank you
Thank
very
you.
much.
Hello, Alex.
You need to unmute yourself, or can we unmute you?
Oh, he did it.
I think I unmuted myself. I tried. I missed the first hour, and based on the first half hour of this time, I have no idea what the subject is that we're supposed to be talking about. And when I look at the list of participants, it seems to me it's people who are already pretty knowledgeable about this. And so let me respond to one thing that Jesse said, an interesting comment that Jesse made, and then also toss another question in several directions. I think Jesse's comment about that the arguments that were being made were majoritarian is true, but I think that it's a mistake to believe that people who make majoritarian arguments believe in majorities. And I think that is emphatically not the case right now. And that there's a question for in any political competition or contest or whatever, you have to try to get legitimacy. And in the modern world, the most widely accepted form of legitimacy is majoritarian preference. So even Vladimir Putin, that noted social democrat, has elections. He doesn't want to say, well, I rule because I control the whole apparatus. And I think that what we are looking at that's relatively new, maybe very new, is the deployment of, in situations of conflict like the one that Jesse described, the deployment of majoritarian arguments by people who really are not majoritarian anymore, and who don't think that everybody should really be casting ballots. And, you know, the racial pieces of, you know, what happened in 2020. I mean, in effect, a lot of the court cases and a lot of the majoritarian arguments were saying people who live in cities with lots of Black people in them, you know, there's a lot of fraud there. So, you know, those votes should really be tossed out. So I raise it. I mean, I think we're in a very worrisome, a newly worrisome period. It's not absolutely brand new. I mean, God knows in the South in the late 19th century, you know, when there were in effect state coups going on, you know, nobody was overly worried about majorities. But I think that, you know, I would like to believe that there was that consensus, Jesse, but I'm not quite accepting of it. Let me move on to my second point, since I have John Koza and Jesse here, and I don't, which is one of the things that I take away from the 2020 election is that we all agree. I think probably everybody, all the participants and everybody who is listening to this agrees that the Electoral College is an abomination, you know, and it's not a democratic institution. It falls short in so many ways, as John reiterated. I think we agree about that. But one additional takeaway that I was actually going to say that we've all believed that for a very long time, and I have believed that for a very long time. But somebody today told me they listened to a recording of an interview I did with Terry Gross in 2000, in which I was much more temperate in my condemnations of the Electoral College than I have been since. So, but in any case, I think we all agree about that. But look, but there is a different takeaway from the 2020 election to me, which is that a successful electoral structure, a successful electoral process has to be simple, clearly understood by the electorate, sort of transparent, recognizable, and durable. That's not true of the compact, I'm sorry to say. The National Popular Vote Interstate Compact, and as John knows, I was an initial supporter of the compact, and I have wished him well in all of his many years of endeavor on this, and I commend him for it. But when I look at the idea of the compact, particularly in the wake of the 2020 election, what I see is adding a whole new layer of intricacy that people can try to game, including gaming whether they want to have the compact rules in effect for one election or the other rules. And I wonder whether, you know, I mean, John, your position has been very clear for a long time, and I know, Jesse, you've written in favor of the compact, but I wonder whether the 2020 election gives either of you pause.
Yes. I mean, look, yeah, this is maybe a different conversation and a longer one. John's logic is impeccable. I've always been compelled both by his logic and the sheer volume of data and argument that he's compiled in the book that is now in its fourth or fifth iteration. And yet I agree with Alex. Just as a general matter, there is the concern of the complexity of it, and B, what we saw happen in 2020, I think opened a Pandora's box of potential reactions to something like this. It was questionable even before what happened in 2020, and then you see this, and you see this invocation of independent state legislature doctrine. I know, John, you say it's something that you favor insofar as it gives the legislature the power to decide how to award electors at least before election day. And I would agree with you there that it does give legislatures that power. And I think that sounds like there's some, this is part of what this convening is about, is Mark making the argument that it may not be so clear. But I think that even with that clarity, my concern really is the way that this whole part of the electoral college process has been weaponized would undermine any even very strong effort, say like a ballot initiative in Michigan, like you're suggesting, to invoke the popular vote compact. I have a response to, or I would like to continue the conversation regarding Alex's point about majoritarianism, but I'd like to hear John respond also to Alex's question. You're muted, John.
Well, you can come up with all kinds of scenarios, but the National Popular Vote Compact rests on the very same foundation as the current system, which is that the states arrive at their vote totals and make a so-called final determination, usually within 3 or 4 weeks after election day, but in any case before the so-called safe harbor date. At that point, their vote counts become conclusive under the current Electoral Count Act, and the electoral votes get cast a week later. Sure, you can contest elections, and if you can get riots in the streets to prevent the Electoral College from meeting or prevent Congress from meeting to count the votes, you can undertake a coup. But you can do that under the current system just as easily as National Popular Vote. And the National Popular Vote Compact is no more shaky than the current system. It depends on the legal system to come to a conclusion state by state on the vote. And by the way, the constitutional amendment that passed the House by a bipartisan 4-to-1 vote in 1969 that Senator Birch Bayh championed and pushed for a whole decade, it also left it up to the states to reach the final determination using their own laws and their differing laws under the federal system and submit the numbers. So I don't know what alternative you have. A federal constitutional amendment, at least the one that the US House passed by a 4-to-1 margin, and the US Senate almost passed by a almost 2/3 margin, but didn't. They rely on the very same system, which is that the states run elections under a federal system and count votes. And yes, it's subject to litigation. Yes, it's subject to abuse. Yes, it's even subject to riots that can overturn the government and produce a coup. But to wave your hands and say that the National Popular Vote Compact is somehow shaky, well, it's no more or less shaky than the current system. And it frankly, no more or less shaky than any constitutional amendment that would pass, because you can be sure that if there's ever a constitutional amendment, which by the way requires 38 states, not states with the majority of the electoral votes, that amendment is not going to do away with the federal system that we have where the states run elections. So it's a fantasy to wring your hands and worry about all the things that could happen. Yes, they could happen, but that can just as easily happen under the current system.
Look, John, that's a contentious set of statements, and I don't think you can continue dismissing all questioning about the compact as fantasy. The fact is, yes, under any system, there could be abuses, there could be riots, there could be a coup d'etat. No one is saying that. But let me ask you a specific question, and I never use the word shaky to describe the compact. I think to me, it's worrisomely complicated. And let me focus on one question, which has to do with durability and the predictability of a system. Under the compact, you could suppose you get enough states to sign onto it, and suppose it clears all the legal hurdles which will arise at that point, and those are two big suppositions. And suppose you run an election according to the compact, and then a year later, a bunch of states say, no, we didn't like that, and they start calculating their partisan advantage. And they say, so now we're going to pull out of the compact, and then you might not have enough states to have the compact endure. So then you would have a system which I would regard as unstable, where in the next presidential election you'd be holding the election under a different set of rules. I think that that to me is worrisome. That's what we really need is a set of institutions that are completely transparent to every citizen, and that are the same and routine. That's, maybe that's just my preference.
Well, it may be your preference, but the fact is, you can't tell people what to do in the future. The reality is, if there's ever an election run once under a national popular vote, the candidates will campaign in all 38 states, which they don't do now. And the differences between the two systems will be very obvious to the 38 states in the country. So yes, it could happen that things will change. But as Jesse pointed out, an overwhelming majority of the American public has supported a national popular vote for a long, long time, and currently does. There is no reason to think that if you run one election where you give the public what they want, that suddenly the public's going to change their mind. And frankly, if they did, that would be their right.
I'm not arguing against a national popular vote. I'm arguing about equating that with the compact. That's in my mind, those are potentially two different things.
If I could jump in.
Please do.
If I could jump in, this so-called, the almost 16th Amendment that was got a 2/3 vote in the Senate in 1869. It's the simplest proposal that I've ever seen. I think it's the only one of its kind. It basically mimicked Article 1. It started off saying the people will elect. The states can, the current system will be kept in place. The states can do as they wish, but Congress has the authority to override that and to set a national, which Hamilton said in Federalist 59. That's kind of the existential bottom line. As a government should be able to assure the orderly and proper replenishment of its own officers. So, I mean, there are a couple of tweaks on that. I think one thought is use the first 27th Amendment, i.e. the one that Madison first sent to the states but didn't get ratified for over 200 years, which is you delay a congressional increase in salary by one Congress. So you're not going to have Congress screwing around with the rules of the national election in the 2 years running up to the national election. That's stability, that's simplicity, the idea that Congress should be able to set the rules. It might do proportional representation, which requires the election all throughout the nation. You keep the 2-vote advantage for the small states, unless Congress decided it was going to go with a national popular vote. You might have a super majority requirement for that, since that does change a little bit the constitutional balance. It's just to me, it's an elegant simplicity. Maybe it's a pipe dream, given that $1.6 billion is being allocated to try to keep make it impossible for there to have a standard rational system. But given that what we're looking at is intentional, aiming at destabilizing and fracturing and making it impossible for us to have a proper system for electing our president, maybe that statement that Congress ought to be able to do what it wants would have some political purchase, but it may be a pipe dream.
Can I ask a question to any or all of you? And this gets back to the majoritarian point. I take Alex's point about people will use majoritarian logic and language who are not themselves majoritarian. I absolutely, point taken. Nevertheless, I think it is important to note the types of rhetoric that are used and who are the audiences. The audience was not perceived to be people who said, people who would say, oh, great, let's throw out the votes of the people. It was believed to be people who would accept a majoritarian argument. I agree with you that the racial element of the arguments and of the legal strategies of the Trump team was very evident. But I raise this, or I come back to it, because I think it's a really central part of this whole debate over the independent state legislature doctrine, which is, how does the public going to respond to all of this? Like, we don't often talk about that, and I think we really should talk about it. And I'm curious what you all think. You know, we talk about this as essentially usurping the will of the people, right? Not at the national level, which we've now seen happen twice in the last 20 years, and very well could see happen in the near future, but at a state level, where I think people do still feel a lot of ownership over their results. And I wonder, let's say that the Supreme Court rules as I wouldn't be surprised that they rule, and they uphold some version of the doctrine in Moore v. Harper. What do you think actually, how do you think this actually plays out on the ground with people in the states? And I mean, I'm talking red states as well as blue states. And certainly if I'm talking red states, I'm talking purple states, which are the states that we, you know, under our current rules care about the most. Maybe you can call me naive, but I am of the mind that that people would not be okay with their legislatures altering the results of their state, as long as we have winner take all allocation, which we do almost everywhere, that people would not be okay with the reversal of a vote count and of the people's rejection of the will of the people of that state. Tell me that. I mean, you can tell me that I'm completely bonkers and naive, but that's where I come at it from.
I completely agree with you. And I've suggested that there are two things that could be done politically. One is to have state constitutional amendments put forward that say the people will elect, as is currently the law in Colorado, was the law in South Carolina in 1868, so on and so forth. The other is for Congress to say, I think they have the authority under Section 2 of the 14th Amendment, and they're entitled to interpret the 9th Amendment as they wish in terms of what are the rights of the people in a Republican form of government, to say they are not going to count the votes of states that where the legislature intervenes and doesn't permit the will of the people to be manifested. So those are. Is there a lawyer here who could explain? I'm you or anyone else? No. I'm saying, is there? I know there's a lot of lawyers on this call. Your idea about about states' constitutions, would that not be overridden by Article 2, Article 2, Section 2? No, if you believe in the independent state legislature doctrine, it would be overridden. But if you think that the state means the people, as it does in Article 7 or whatever.
But you mean
the people, the
legislature, the people, right?
No, the state shall appoint in the manner, and so if the state is the people,
directs, right?
No, but if the state is the people, it's the state that shall appoint. The legislature may direct. That is, the legislature must legislate. The legislature can only legislate in accordance with its constitution. The people get to establish the Constitution. I mean, I think the South Carolina constitutional provision was correct. I think the Colorado constitutional provision is valid. And so anyway, that's my argument for that. And I think it's a great issue to take to the people in an election.
I agree. I agree on that.
That's true. People would have difficulty voting against the notion that they should have a right.
That they should vote.
President. Yeah.
I mean, it just seems to me like it's a no-brainer. I floated this. It's proposal. Those proposals are in our law review article that it's published. It was published in Lewis and Clark. They're in the appendix.
It's a good idea.
I think that the political trickiness of it would be that suppose the court does do what you fear, Jesse, or what we all fear. It won't become an issue until it becomes an issue. It won't become an issue until some state legislature, and it's not going to happen in lots of places at the same time, probably. It's going to be until some state legislature takes a funky action, which will be disguised in certain ways and sort of dressed up in others. And I mean, I think people, it's a tough issue on which to make clear to people in advance that this is something they should be concerned about.
Yep, it is. But we know the states where it's going to happen. If it's going to happen, we know where they are, right? We know it's half a dozen states we could name right now. It's going to be Arizona, it's going to be Pennsylvania, it's going to be Georgia, it's going to be Wisconsin, maybe Michigan.
Yeah, but wouldn't there be liabilities for the states that attempted to do this?
That's what I'm saying.
Wouldn't it be politically damaging to them?
That's my argument. Yes.
I mean, you can put it to the people in Michigan and Arizona. That's what I've been thinking should happen. I mean, there's an initiative, a positive initiative going forth in Arizona this election cycle. I mean, why couldn't that have said the people are going to elect the president? Develop some groundswell for, win some elections with 70% of the vote, and maybe Congress will act and say, yeah, we agree. I mean, this is just you're saying Michigan passed the state constitutional amendment requiring that the electorate
vote of the people
uses the electors.
Yeah.
And wouldn't you love to see the campaign ads against that?
I mean, right. I mean, how do you I think that's actually a good point. How do you argue against that? It's a hard thing to say, no, you shouldn't have to say to your voters, you're voting yourself out of power. Nobody votes themselves out of power.
Yeah. But wouldn't they be saying that that as interpreted with the independent state legislature doctrine, that the legislature has the right to override the state constitution, right? I mean, they would be making that case, and they would probably, I'm trying to imagine how, if I worked for them, I would dress up the argument, and I'd probably say stuff like, elections here, popular elections, there's a lot of fraud. There's a lot of, you don't want to sort of, you don't want to trust it to, to their state, I don't know. I've never tried to think through their strategy, but
Senator Benton has a great 3-page speech from 1824. It was republished in 1877 as one of the most important speeches ever given about the Electoral College. You just take it out and retread it. I mean, he makes every point you could possibly make about how a legislative election is grossly wrong.
Well, on that point, Mark, and picking up on some of the historical points, the fact is that a majority of the U.S. Senate and a majority of the House, well before 1824, had already voted to require elections.
Right.
So I don't think that Benton is being so new in 1824. I mean, it's he's right. He's riding a wave, and he had a very loud mouth, but the wave existed.
He did, but he was saying you don't need a constitutional amendment. It was a usurpation from the beginning. You could just not count the electoral votes. So that's what I'm suggesting might be a statute.
It is sort of true that the last time it happened by state action, like in the 20s, in the 1820s.
Yeah, the states just did the right thing.
The states just did it because after the corrupt bargain election of 24, there was this groundswell of public opinion that, proclaimed the Adams presidency illegitimate.
Look, we don't need to get into an arcane historical argument, but it predated.
There's no such thing.
It predated 1824. Most states ended up before 1824.
Yeah.
And the denunciations of legislative, usurpation were common in the teens. So
right.
But there's the Supreme Court.
We didn't. You try do it again, Avi. You've muted yourself. Avi, we can't hear you.
Okay.
There you go. Nope, now it's muted again.
Okay, here we go. Okay.
Okay.
Okay. So then there's the Supreme Court, and I didn't mean to, just emphasize what it is that I pay a lot of attention to, but the Supreme Court has mucked around. Bush versus Gore is a prime example of how the votes are counted, right? And Gore may have asked the wrong question, but wow, did the Supreme Court get involved? And then using McPherson, among other things, get accepted by the American people. Gore was, of course, noble in his concession, but you mess with the Supreme Court, as very good politicians have found out, like FDR, for example, and it is some kind of a third rail. So I think this independent state legislature doctrine has all sorts of dangers within it. I was on a panel with Charles Freed about Bush versus Gore. And I said, how could it be that you ignored the Florida High Court? And he said, oh, everybody knows that was a rogue court. Well, once you could make that kind of, and I don't mean Charles Freed is always making that kind of argument, but that's the argument he was making at that point. And that's kind of what I meant to suggest about federalism. I mean, it comes and goes. And so trusting that the court would go along, I mean, activist court used to just mean we don't like the result, but we have an activist court and we have great danger from that court. And I certainly don't mean to say the text doesn't matter, but I think we have to be conscious of what the court is likely to do if there's any kind of significant change, though I'm all for it, but I'm not optimistic.
And of course, it should just be said to say it, which is that the reason that we're having this discussion at all, and the reason that we're facing Moore v. Harper, and the reason that we're having this panel here is because the two institutions of government that Republicans control unequivocally are the Supreme Court of the United States and the state legislatures. And the one going to the other to ask it to lock in permanently its unquestioned authority over its choosing of the president is obviously no surprise, right? It is an unquestionably partisan action, and it is a partisan action in search of a legal theory, right? Which you could probably say is true for a lot of things, but this one is just so blatantly obvious because it's all happened in the last decade.
But we're in deep trouble when it's Mike Pence with the advice of Dan Quayle, who saved the country, right?
Dan Quayle, who beat Birch Bayh, kicking him out of the Senate. So it all comes full circle, right?
And one more thing about Reconstruction, and certainly Mike can jump in too. I believe the 39th Congress really thought that they had to run Reconstruction and run the country. They didn't trust the Supreme Court for very good reason, and they certainly had very little use for Andrew Johnson. And so it was Parliament that they thought they were going to be. So if you want to go back historically, that's an important datum, not that the Supreme Court stood for it in slaughterhouse cases, civil rights cases, and on. But I do believe if you were looking for some kind of historical intent, there it is in the 39th Congress.
Well, the 39th
and the enforcement clauses.
I think this is the 39th Congress, when a Supreme Court justice dies, don't they actually take the number of Supreme Court justices down one to prevent Andrew Johnson from appointing? I believe that happens. And then they added it back again when Grant was president. So they certainly asserted the power to reduce the number of justices at that time, precisely for the reason you described.
Perfect. Can I ask the question?
Yeah, I'm not quite sure how we answer that.
I'm not sure I understand the
Looks
question.
like a question for Jesse.
Okay,
Yeah.
well, go ahead and read it, all right?
Okay, Jesse, this is a question for you. So people are not okay with gerrymandering, obviously, in places like Louisiana, Alabama. However, the legal system says that it's legal to do what has been done. Obviously, the Supreme Court says that. And obviously, if you prevent the state courts from having any access, any ability to intervene, that's another barrier. Lacking any legitimate path to challenge the actions of the legislature, what would you suggest?
Oh, yeah, sorry, I should have been clearer. I didn't mean that there was an obvious legal remedy. I meant that there would be social, societal, and public outcry that would, that could conceivably influence the course of the political debate. Obviously, you saw this happen in a very horrific way on January 6th. And we're still dealing with the fallout of that nearly 2 years later. And I'm not suggesting that that should happen or that that will happen, but that it is true that public gatherings and public rejection of a quote unquote of a legal of a process that's been undertaken with legal imprimatur of the Supreme Court could still be significant in a way that could affect the longer term political debate and even the outcome. I'm not calling for riots. I'm just saying. I'm just saying that at some point people won't. At some point, and I'm actually am okay with people peacefully protesting. Something a state court doing this, even if it does so under legal authority.
Well, I mean, I think the last gerrymander in Alabama is 6-1. And
Yeah.
just saying that out loud
Yeah.
it kind of demonstrates that there's this continuity between Alabama's past and its present.
And he should know because he's an amicus in that case. He's one of the Alabama historian.
I've been hanging out with lawyers lately.
So this is a question for Dr. Koza. What do you think about Heather Gerken's Democracy Index? Would that help alleviate some of the issues with the Electoral College? I don't know the index, so I'm not sure what, but anyway.
I'm not familiar with that. I know she wrote a book. I have not read it, so I can't answer that question.
Well, it is 8 o'clock. Do you want to invite any other panelists to join you?
Sure. So we have 2 more panelists who can, or 3 more. One is Pat Rosenstiel from Dr. Koza's consultant and advisor with Dr. Koza's group. One is Anastasia Belladonna Carrera. And one is it Paul Huffman? I think I gave you the name. Paul Huffman, yes.
So who do we want?
So yeah, we want to invite all of them to join us.
Yeah, Devin is pending.
Anastasia is the director of Common Cause Minnesota. Paul is, there you are. Paul is a volunteer, but has a senior position with League of Women Voters Minnesota. I'm not sure if Pat is on the.
Yeah, I'm here. Thanks for
Oh,
having
okay,
me.
There you
okay,
are.
there's Pat.
Appreciate it.
Okay,
Yep.
great. So Pat, I had indicated you'd be the first one to jump in on part 3. So why don't you do that, since that's what I told you?
Guess I'm happy to do that. I mean, I was enjoying the conversation. I am probably less academic than most. I obviously am a full-throated proponent of reform, senior consultant to National Popular Vote, have talked to fewer professors and sort of more legislators and sort of party leaders on both sides of the political aisle related to reform. I should say I might be the gorilla in the zoo that everybody wants to take a look at, because I am a Republican, a lifelong conservative Republican who supports a national popular vote for president. And my experience tells me there's only one way we are going to get it, which is the National Popular Vote Interstate Compact. I think it's the only way we're able to build bipartisan support. I think Jesse raised some interesting issues about majoritarian rule. I can tell you that I'm a proponent of the national popular vote because I believe the candidate with the most votes should be elected president of the United States. And the reason I believe that's important is because, you know, I think one person, one vote is a foundational principle of American democracy. I don't think that's a Republican or a Democrat idea. I kind of think it's an American idea. I think the current system's crashing under its own weight. And I think it's only a matter of time before the compact takes effect. Now, I might be a little biased because, you know, I have some experience in the trenches on this issue, building bipartisan coalitions to support a national popular vote for president. I also think that the thing that kills movements most, political movements most, as a student of political movements and reform movements in America and a participant in them, is the idea that we want the perfect always to get in the way of the possible. And I guess the one message I have anytime I join groups like this, having listened to lots of smart people say lots of smart things, that let's start from first principles. And the first principle is we need a national popular vote for president. We need to have a national popular vote for president because every voter in every state needs to be politically relevant in every presidential election, because that's what allows us all to buy into this social contract that is the American political system, that is deeply threatened, and its future is deeply threatened and challenged right now. And so if the first principle, and I've been listening to this durable, understandable doctrine, which I do agree with. I can't think of anything more understandable and durable than the idea that we're going to have a national popular vote for president. I think the understandability is baked into sort of the process we would use to elect the president, which is every American voter would know that the candidate with the most votes is going to be elected president. Every American voter in every state would be relevant in that process. And I think that understandability will create the durability for the compact. Now, Professor Kassar, who I have a great deal of respect for, talks about, sort of this idea that withdrawal clauses of the compact create instability. It also creates sort of the kind of reform that voters of all kinds or political ideologues of all kinds can buy into, because I can tell you that in 2018, 2 years after the last divergent election, when 15 Republican senators and 10 Democratic senators in the state of Michigan came together to introduce the National Popular Vote Interstate Compact, when they agreed that we should have a national popular vote for president, I will say many of those members, a majority of both conferences, and I don't know how many people, I know there's the League of Women Voters here in Common Cause, and they know how hard it is to get bipartisan support for election reform. I can tell you there would not have been 15 Republican senators and 10 Democratic senators on a national popular vote bill unless it did preserve sort of state control and state powers of elections, right? And that's a very important part of the interstate compact to build lasting political support for this reform. Now, I will just say, I think I'm here to talk about, I'm from Minnesota. I'm senior consultant to National Popular Vote. I've talked to more political activists, political leaders, grassroots groups, and legislators than most people breathing on the issue of a national popular vote for president. And I mean that on both sides of the aisle. I'm here to tell you that I'm bullish on the National Popular Vote Interstate Compact. I believe that the National Popular Vote Interstate Compact will take effect. I believe we will have a national popular vote for president. And it's not a question of if we will have one, it's a question of when we will have one. And I would just say the reason I'm so bullish about that is because I've had the conversations with the people who matter, the legislature, right? We've been able to build that bipartisan support, but I also point to the recent Pew research, which demonstrates it is only a matter of time if we get out of our own way as proponents of a national popular vote for president. And the Pew research that has public opinion supporting a national popular vote for president at 63% is only one little piece of the story. The real piece of the story is that voters 18 to 29 support it with 70%. 7 out of 10 voters, 18 to 29, believe we should have a national popular vote for president. And there's only one way we're going to get one, which is the plan at nationalpopularvote.com. I will also say that voters 30 to 49, 65% of voters 30 to 49 support a national popular vote for president, right? So voters 18 to 49, more than 2/3 of the voters support a national popular vote for president. Over time, the people get what they want, right? And I'll say this, I've talked to more opponents of the National Popular Vote Interstate Compact. I'm hearing from more today, surprisingly some more. But there are two kinds of opponents in my mind of the National Popular Vote Interstate Compact. I shouldn't say this. There are only two kinds of opponents for a national popular vote for president, right? Those who are afraid of the voters or those who are afraid of their ideas, right? And I will say that anybody who can do something about this, not write about it, but actually do something about this, right? If you're afraid of the voters and if you're afraid of your ideas, it's probably time for a new line of work. If your life and line of work is American politics. So I will tell you that I am a full-throated proponent of the National Popular Vote Interstate Compact. I am that way because I think it's the only way we're going to have a national popular vote for president. I believe the compact will do exactly what it says it's going to do, which is guarantee the presidency to the candidate who wins the most popular votes in all 50 states in the District of Columbia. And by that, I mean the red states, the blue states, and the purple states. And I think that's important because I think as a Republican trapped behind the blue wall in Minnesota, who could have cleaned my gutter on every election day, right? And have had as much impact on the results, right? Because I'm a Republican who lives in Minnesota, the only state that voted for Walter Mondale, right? Like I feel the same way as a Democrat in Oklahoma, right? And that is what is the most existential threat to what I believe is the greatest system of government that man ever conceived of, which is this man and woman, but which is this American democracy where the power derives from the people. And at the end of the day, all of the, I don't want to call them parlor games. I think they're like really important conversations that we're having here. But my parting shot is this, that if you want a national popular vote for president, there's one way to get it. Because I don't see 38 states adopting a constitutional amendment. And that this idea that every voter in every state will be valued in a presidential election, that is a stable, that is a foundation that is understandable and it is durable because it's what the voters want. And we should all get our shoulder to the wheel and give it to them. And I'm just grateful to have been invited here.
Thank you, Pat. So Anastasia, you want to take it up next? You need to unmute yourself.
There we go.
Sure. I'll give it a whirl. I'll give it a shot at this time in the CLE presentation. So first, I just wanted to say thank you so much to everyone that's joined us. So many of the perspectives and voices and expertises that we have. What I'm going to try to do for the next few minutes, if I can, is just sort of, as I'm listening myself and learning to, from the discussion, I think I just want to ground, I want to ground this for just a sec and really sort of regroup around why is it that this conversation right now is just so incredibly important to have at this time. And so we've used terms and we've talked about, we've said more V. Harper and things like that. We've referenced where we are with SCOTUS on those things. But I think it's important for us to pause for a second to really think about fundamentally, what is this about? It's not even so much about the theory of the independent state legislature as when we kind of peel away all of those layers of the complexities, what it really comes down to is a power grab. But it's a power grab within the context of redistricting. I mean, that's why we're here, right? Because North Carolina went through its redistricting process. Republican-led legislature drew what's been considered and called extreme partisan gerrymandering. They took it to state court. The state court agreed and said, agreed with the communities, the people, and said, yep, this, you can't do that. This is in violation of the Constitution. And then that was appealed to SCOTUS, right? So when we really look at it again, it's fundamentally about what is really the significance when we talk, we talk about voting rights, we went through the history of it, we talk about our Constitution, we went through amazing historical context to the development of that, even some of our founding fathers debates when our own Constitution was being formed. But as we're looking at this right now, right here today, this evening, what we're really talking about is fundamentally our individual power within a system and a structure, an institution of power that perhaps might have not been written back then or created back then to really reflect everyone that is today and currently what we consider to be American societies, right? And so it begs the question of why the power grab? Why all of a sudden now do we see this power grab by a given group, right? Within this context, attempting to shake the very foundation of what, folks have heard, the discussion around precedent. I mean, as a lawyer, I mean, that's like sacredness, right? If this is longstanding precedence, boy, for you to change something like that, it really is going to take a lot of legal debate. And yet we're really talking about this in a rather, I don't know if flippant is the right word, but like it's almost like normalized, right? The idea that some of our institutions, some of our democracy's foundation, because that's really what redistricting, I would argue, is. We have the power to vote, but what does that power to vote sit on? It sits on voting maps that are drawn. And we presumably think that they're being drawn in a way that's fair, one person, one vote. Well, it's much more than just one person, one vote, right? Because people have stories and lives. We're not talking about just the geography that happens when you're shifting districts, right, to comply with census data. We're talking about communities and people that live and breathe and thrive within these areas. It's not just a numeric exercise. And so when you're looking at that and you're looking at the foundation of what we're talking about when we talk about voting rights, there you have redistricting. And then you go to, I would say, go a step further. So then where's the power grab with redistricting? Well, someone already started laying the foundation for that, right? And why this is such an urgent matter today, and why is it that we have these amazing individuals and the CLE this evening trying to sort of peel back some of those complex layers in a way that we're able to relate to. Because we're not just here, I hope, for the 3 CLE credits. I hope that we're here because the matter of voting rights is something that is now really drawing your attention. And you want to know, either as an attorney in this space right now, or just as an individual, just as a Minnesotan, just as someone of our, American family, the broader American family, what could we do to protect the integrity of when we say my vote matters? I want to cast a ballot that I can cast and know that it is counted. What do we mean about that? Well, as I said before, I would argue that as we're looking at everything we've been talking about tonight and what does all of this mean, where are we looking at? I think that, to put it in simpler terms, when we talk about power grabs, we're really just looking at this. We're either going to be a democracy and a society that says that everyone's vote matters and that everyone's voice matters, and support to nurture that kind of an institutionalized structure. And this is where you can either go into the national popular vote, further discussion as a viable way of making that a better reflected process. Or we can look at other reforms people have brought to the table. I think there's been a consensus so far in this discussion that the electoral college process is very broken and not equitable. But before we can even get to those arguments of reforms, I think that we need to just sort of bring it on back and talk about it with regards to terms of when we talk about voting rights and we talk about power grabs, we need to start calling out what we're seeing here. And what we're seeing, I would argue, is a focused, well-funded effort to further disenfranchise and roll back the voting power period of an increasingly growing demographic in the state, in not just in the state of Minnesota, but in the country, I would argue. And there's this group that believes that with the increase in population of that demographic, they're going to lose power. They're not in a position to earn the vote, so they've got to cheat to grab the vote, right? And so the dangers, I heard this come up before, and then I'm going to hand it over to my colleague at the League of Women Voters. Actually, Paul has been a very important part of our collective effort in the state of Minnesota. I know Paul and I are going to be working as well on coming up with a new, some revised reform bill on an independent redistricting commission. So he's super, I'm really glad to see that he's going to be a part of talking with me about this. But I think that in trying to figure out where the threats lie with this idea of an independent legislative body that's able to essentially usurp all power out of the hands of the people in contradiction to the state's constitution, to federal laws. I mean, we got to figure out a way of talking about this issue in bite sizes that folks that are in this space can turn around and go back and continue those discussions in their own settings and in their own groups. And I would say that to do that, we just need to really focus on what are we really talking about here when we talk about this independent body. We're talking about a power grab that may not, I would even argue, I don't even believe they believe their own theory. I just think that their theory is a way of moving an agenda of a specific group of people, right? And I would because I mean, come on, they've got their own, I mean, all of us here are lawyers, right? Most of us, we know anybody can sue anyone for anyone, any reason, anytime. Right? Just because I bring a lawsuit doesn't mean that by itself it's got some kind of legitimacy to it, right? Let's just, okay. So the fact that they're just even bumping it up, I think, I can't remember who it was, but someone made the connection between, okay, we've got a state that's got the legislative control in a specific party who also has the SCOTUS stacked up in a specific way, right? So is that really because they believe in the constitutionality of what they're trying to schlep? Or is it what I'm talking about, which is really more of a power grab that, whether they really believe that's a theory or not, they're just kind of volleying it. Those of us that play volleyball, somebody sets it up, somebody spikes it, right? And so I think in order for us to take back that narrative and to really mobilize at the grassroots level, to hold power accountable, particularly at this point in time where we are right now, moving into the midterms, setting up for the 2024 election, I think that is definitely a side to this discussion that I'd love to hear my colleague Paul talk about some more within the frames of, what we're seeing on the ground here in redistricting reforms and how we can work to protect the right to vote in a very organic way that communities can understand, right? Because for us to sit here and theorize about these things is great. I learned all kinds of new stuff too. But what does that mean? What's our call to action? I've talked to Mark a lot about this, and I know that there's a call to action. We want y'all to do something more than just listen to us. So Paul, you want to join me in this sort of discussion, and maybe we can just banter back and forth and maybe call back in Rosie and have him really make that spin from this issue to what I'm talking about with regards to how do we sort of demystify this and really put it in the language that everyday Minnesotans can really understand, digest, and walk away with a good call to action.
Yeah, so if you don't mind, I'll go ahead and jump in. Thanks, Anastasia. I'm Paul Huffman. I wear a couple of hats, as Anastasia alluded. On the one hand, I'm the redistricting coordinator with League of Women Voters Minnesota. I've worked a lot with Anastasia, Minnesota Council on Foundations, quite a few other community organizations in Minnesota and nationally on redistricting. I'm also a member of the board of directors of League of Women Voters Minnesota, where I'm the co-lead of Voters Service, which is a strictly, non-political, nonpartisan services, support, information to voters to enable them to engage in elections. I come at this from the perspective that the League of Women Voters is focused on ensuring, among other things, fair, secure, and accessible elections. And the presidential electoral process, the whole discussion around Moore v. Harper, those are really central to that. From the standpoint of the presidential electors, the Electoral College, that's something the league has been reviewing and considering how to come down on that. And so I won't say a lot about that because we haven't established a formal position. Just as an aside, before we get started, I'll mention, I really appreciate, well, one is I really appreciate this program for Mitchell-Hamline Law Review. Not being an attorney, I don't get included in these things. But I find the law very interesting. I actually did take a semester of constitutional law in college, even though I'm in degrees in chemistry. And I enjoyed it very much. All the other people that were in my class are now attorneys, so good for them. The other thing is I appreciated the discussion about the history in South Carolina. I grew up in South Carolina during desegregation and after, and I fully agree with all the dysfunction that was referred to. It is my father who lived there for many years more than I did. He always referred to it as not a real state, and I think he was right. So that's some of my background real briefly. So I come at this from the voting rights, voter access, representation lens, mainly through redistricting, as Anastasia talked about, but other aspects of this. I'll take a couple of quick paths on this. One with regards to, we had quite a bit of discussion about the legislative supremacy doctrine, independent legislature doctrine, that coming up now as it is in Moore v. Harper. We talked about the North Carolina case, and it's important to know that in North Carolina, there's a law in North Carolina that allows for legislative review of redistricting maps. So that was all in accordance with the process approved by the legislature. So this is not some extrajudicial review. This is something in accordance with that. It's consistent with past judicial action in North Carolina. It's consistent with the ruling in Rucho v. Common Cause from 2019, in which the U.S. Supreme Court said that partisan gerrymandering wasn't the role of federal courts. That's left up to the state courts. So, I mean, this is and Allison Riggs, if you know Allison from the Southern Coalition for Social Justice, fabulous speaker. Anastasia and I had a chance to listen to her at noontime today on a program. And she was part of that Rucho v. Common Cause. And she's really unsparing in her legal parsing of this proposal that the North Carolina Supreme Court overturning those maps was contrary to the Constitution of North Carolina due to this independent state legislative doctrine, in the lack of judicial sense of that, I guess would be the kind way of saying it. And so, that's really concerning. If the Supreme Court takes an approach that allows application, opens the door for this independent state legislative doctrine, I see this being very similar to the Dobbs decision, in which the Supreme Court said in their decision, oh, this is only applicable to this one special situation. It doesn't apply to anything else where that may rest on similar judicial language. As attorneys, you all know that once you get a tool, and I worked in engineering most of my life, engineers are the same way. Once you get a tool and you figure out how to use it, you will use that tool for other things. And as an attorney, you're going to find that tool. If this, for example, if it's not verbatim written in the state constitution or the US Constitution, then the Supreme Court in the case of Dobbs has said that, well, it doesn't exist because it's not explicitly in the US Constitution. If SCOTUS says that indeed the legislature has absolute jurisdiction over how elections are run, including redistricting, which is arguably maybe not within the scope of what is said in that part of the Constitution. But, you know, so anything that could be even indirectly related to the conduct of elections is now up to the legislature, and nobody, not the governor, not the state Supreme Court, can challenge that. That throws out 60 years of precedence in redistricting in the states. It potentially undermines all of the federal laws on voting rights, brings those back into question. Everything about one person, one vote, that all rests on this principle that the legislatures can't do whatever they want, because those cases, by and large, which were mentioned early on, have to do with, Baker v. Carr, with Reynolds v. Sims. They rest on legislatures not apportioning or districting their legislative or congressional districts according to population. And it went to the Supreme Court because they refused to do it, just flat out refused. Now, if they say, look, the Supreme Court now says I can do whatever I want as a legislature, those potentially get thrown out. So once, it's the old thing with, you said to your kids, you give a mouse a cookie. Once you give a lawyer a tool, they're going to find other ways to use that tool to get their desired ends. So the potential vulnerability of Moore v. Harper is huge. Something that Anastasia alluded to here is that, and I agree with this personally, this isn't a league position. What I would tell you from all my looking at this, if you look at the long-term strategic effort to preserve power, because elections and redistricting are all about power. That's what it is about. And Patrick, I appreciate you being here. I love hearing what you're saying. And I've been idealistic. I spent 20 years in the military, but at the same time, I realized people are human. And that was James Madison. For all of you who remember how the Constitution read, Madison understood that humans are not perfect. We are not angels. And therefore, there's going to be conflict. And people are going to pursue power. This effort, Red Plan 2010, and really the driving legislatures more toward the Republicans, was part of a long-term strategic plan. The independent state legislative doctrine is part of that plan, coming out of the Heritage Foundation and their groups. That's all part of maintaining a certain power structure. Go ahead, Anastasia.
Sorry, I just wanted to, because what you're saying is just so perfectly aligned, but I think if Moore succeeds, let's say it goes through, legislatures, as we've said, would have free reign to essentially backtrack all these voting rights, right? And I see the policy implications of whether SCOTUS agrees, right, with the legislative members in the North Carolina case that are trying to move this, I don't want to call it wackadoodle, but wackadoodle theory. I just wanted to emphasize that there are policy ramifications that are not related to the theory or the constitutional arguments behind whether it's viable or not, that I think that we really need to be underscoring. And, more would make it easier, for example, for state politicians to create barriers to voting. And I think that's what communities can relate to. It would be easier for them to rig voting maps in Minnesota. Think about it. I mean, think of the process we have in redistricting in Minnesota, right? Now think of a legislature that is now able to do that and know that they can do that unchecked, right? Because the courts, which Minnesota has relied on for how many decades to draw maps, are now have their hands tied, right? So you're going to get a lame duck redistricting body in the legislature that all of a sudden are going to be like revived and want to be all over getting engaged on redistricting, right? They could be, more importantly, and this is what we're seeing now, is casting doubt in the integrity and the fairness of our elections, period, right? So we would start seeing things that in Minnesota, we haven't been used to seeing. So we're talking about voter purges, I mean, think of the toolboxes that have been used to date, right? On the policy end in rolling back those voting rights, dramatic cuts to our early voting. Again, think of why Minnesota has always been like best practices and named across the country, right? As far as like, this is the state, this is the shining light of the Northwest, right? Discriminatory voter IDs. How many times have we been fighting and pushing back on provisional ballots and voter photo ID? So, you know, in essence, it's fewer protections against voter intimidation, as we're seeing this is now becoming a new tool in the toolbox that we have not been in the past aware of. So I just wanted to interject that and to cushion what Paul is really hitting well in his comments, and that is that policy side and implications of what if SCOTUS really were to in any way. And I think it was Jesse I heard say this, and I just cringed because I could so see this happening, which is, okay, maybe they may not necessarily say, you know, a 100% nod, right? But just to look in that direction and saving some pieces of it, it would be horrific on the policy side of voting rights.
So a couple of things I just kind of want to say, which is I like the idea of structuring this conversation around power, right? And politics is about power. You know, elections have consequences. I mean, when you talk about Red Plan 2010, I can talk about blueprints out of Colorado on the left, right? So like at the end of the day, let's just understand that politics is about power. And I'm not going to get engaged in a redistricting conversation, but I will get engaged in the idea that one of the uniquely American ideas about our Constitution is it's about the devolution of power. And like when Avi was talking about, you know, he was talking earlier about selective federalism, right? Well, the truth is everybody uses federalism for their own political prism. There's just, I mean, that's the nature of the beast that is the American system of government based on pluralism, federalism, and democracy. Okay. Now, the one thing I know about is a single member district, right? Because you're talking about North Carolina, you're talking about Minnesota, you're talking about Republican control of the redistricting process. You don't talk a lot about California and Democratic control of the redistricting process.
Oh, I was
right?
going to talk about that.
Illinois.
You'll get
Yeah.
that, but what
New
I'm
York.
saying is like a national popular vote for president, just for a second, right? I don't, again, Professor Kassar was talking about complexity, right? It's really simple. It's a single member district, right? So it doesn't bring into multi-state jurisdictions and districts. And it's all about devolving political power to the people. It's all about devolving the political power of the battleground state voter so that we're all treated in the same way. And I think your position on redistricting is consistent with that, is consistent with that idea and positioning around a national popular vote for president, because at the end of the day, the legitimate form of government that's going to be accepted by the most voters, right, is the one that devolves power to all the people, all the citizens, right, in an equal sort of way. And that's where a national popular vote for president is so simplistic and elegant in its simplicity at some level. So I just, politics is about power, and power, switches hands. There's no question about it. That's one of the reasons I'm so concerned about the ideas of the United States Congress setting the rules, because you want something that's durable. Congress changes hands, right? And the rules will change every time. So I wanted to weigh in on this idea of power, devolution of power. I don't know enough about redistricting to engage in that conversation, but credibly, I guess is what I'd say. But at the base value, that's what I think about as it relates to power and the devolution of it.
Hey, thanks, Patrick. And I was going to, mention this whole thing about redistricting. It's both parties. Well, in North Carolina, you've got Republican legislature overruled by the courts, appealed to the Supreme Court. Same situation in New York, where the Democratic legislature manipulated the maps, thrown out by the state Supreme Court. Now the Democrats have a reputation for maybe trying to be more friendly, nice, something. So they did not appeal to the U.S. Supreme Court because they didn't want to go down that road. So this is a both, and this is gerrymandered map in Kentucky, Republican supermajority legislature, Republican governor, Democratic governor, overriding
that's right.
vetoes. So anyway, I'll stop. But so it's both. But going back, the presidential election, absolutely, we believe that needs to be looked at. And part of that, again, going back to the policy issues with the legislature and legislative authority and that constitutional interpretation. Thanks.
Hey, Paul, I just wanted to say, I didn't mean to interrupt. I thought you were done with your comments when you passed it over. So I thought there was a lull in the action there. So I apologize for that.
No, that's okay. Yeah, not a problem. Yeah. And I've worked a lot with Anastasia, so that's good.
I just wanted to add to the definition of power for the sake of clarity in the conversation. So when I talk about power and politics being about power, I'm also including the power of community. So it's not just the power of the usual power brokers being partisans in that dynamic, but being mindful that power dynamic in politics also includes the constituent that bestow that power, right, onto an elected that's part of the responsive representation dynamic. So there's also a people power, factor in there.
So I just want to say, it's been 2 hours and 45 minutes. You don't know this, there are still 50 people watching. So I want to thank the law review, not only for accepting our article, but for agreeing that we should try to do something like this. It's more or less probably not all that precedented for the law review to hold a public event around an article. And I want to thank all of the folks who have been out there watching for the last 2 hours and 45 minutes. I hope you didn't find it boring. Trolls thought it was. I know my presentation could be much better. It'll be better next time. But yeah, I want to.
Oh, I'm sorry. I just saw a question, and I think it's probably for Anastasia or Paul. It just says, couldn't redistricting become a smaller issue if Congress and the legislature were larger?
That's an interesting idea.
Seems to me that would be a question you guys would tackle.
So I'm actually intrigued to hear my colleague Paul's response to that, just to see. We do this all the time. Because we're about to start working together again, as I mentioned, on a reform bill. So Paul, give it a shot. Let me see what you think. Let me see what you have to say about that question.
Yeah, I think the short answer is no, I don't think it'd matter. Redistricting is about, if you look even from a business standpoint, I spent many years in business. Whenever you're doing something, it comes down to people, principles, and process. The people are still the same. The principles are still what they are. The process is still the same. If you're slicing a pie into 8 pieces or 100 pieces, it's still the same process, still the same people, and you're going to get the same result.
Yeah, I would agree. That's why I'm like, let me see what Paul has to say. I would agree completely with Paul, only because the dynamics of that power and that fighting between the two majority parties at this time, right, within the system and the process that we have, wouldn't change. Like the partisans on each side, their desire to manipulate the process of redistricting to give themselves an unfair advantage to keep control and power wouldn't change, to Paul's point, whether there's 100 pieces in that pie or 4 pieces in that pie, right?
Can I throw in something that?
Oh, I was going to say, the only thing I'd add on that topic as it relates to when redistricting comes up, as it relates to electoral college reform, in case anybody in the audience is interested in that piece of it, it's when people raise the prospects of a congressional district reform, right? The Constitution leaves it to the legislature to determine how states are going to award electors. In Article 2, Section 1, many people who have a problem with the current system, but are a little leery of a national popular vote, they're like, let's do a congressional district system, right? I believe a congressional district system takes a bad system and makes it worse. You know what I mean? It makes fewer voters relevant, not more, because then all of a sudden we're about, competitive congressional districts having all the power with the president. And then anytime we have that conversation, it's like, you think redistricting bad now, let's get the Democratic National Committee involved and the Republican National Committee involved and the staff for all of the presidential candidates on both sides of the races involved in redistricting, and see how far away we can get from community involvement in redistricting, right? So like, as it relates to power, as it relates to the electoral college reform, I would just say a congressional district system, one of the reasons it takes a bad system and makes it worse is because it would invite all of those national players into redistricting, where now it's at least mostly controlled at the state and local level and in the courts. So.
Avi, did you want to say something?
I did, and I hadn't thought of it. I said I would learn a lot, and I did tonight, and I thank you all for that and for the invitation to be here. So John Hardy Lee was one of the great theorists of constitutional law, died about 20 years ago. He wrote a very important book called Democracy and Distrust, and he clerked for Earl Warren and was in many ways the theorist who explained what Warren, he thought, was all about. And but towards the end of his life, he said, what we ought to do, and this is before our computers got so sophisticated and so on, what we ought to do about apportionment and reapportionment is just take a grid and put it across a location. That's the only way we can succeed, which is a radical thought at the time, but is actually an interesting thought and one that may connect to some of the other things said tonight. And I can get you the sites if you want.
I can throw out another radical thought, which came from Charles Buckaloo, the guy who supported proportional representation. He said our winners take all system is fundamentally wrong because it leaves people unrepresented. All the people who didn't vote for the winner are basically unrepresented. So you have vast numbers of people who don't feel truly represented in the democracy. So his idea was multi-member districts in which each person gets to vote for as many votes as there are in the district and can allocate those to anyone they want. So in Minnesota, for example, if you had 60 districts, there actually become 20 districts, and everybody can vote could throw all their votes to one person. So you would actually get a lot of Republicans from the suburbs, maybe even some from the cities, and you get some Democrats from outstate Minnesota, and you wouldn't have this incredible. The Democratic caucus would have members in it who are from rural Minnesota and would be speaking to their ideas. That was adopted in the Illinois Constitution of 1870, and it remained in the Constitution for 100 years. It was well liked. It got to be pretty expensive, so they took it away. And an Illinois congressman really urged that they bring it back, or a state representative. His name was Barack Obama. He thought we should be one United States, not two divided United States. Anyway, as long as it's Common Cause and League of Women Voters are here, just throw that out as an idea that you might want to consider as a way to deal with, in part, with the redistricting problem.
Patrick had something he wanted to ask.
Yeah, and I would just say that this is obviously my opinion, right? Which is like, I think there's one idea that's not broken in American democracy, right? Which is the candidate with the most votes wins. Like I don't think that idea is broken. I think where we become broken, you know what I mean, is when that doesn't occur. And so my sense is as a guy who's lost a bunch of elections, you know what I mean? Like it's not that my elector doesn't agree with me. You know what I mean? It's this idea that I'm not valued in an election. I don't believe it's the most important election in my life, but too many American voters believe that election is the brand standard election, right? So what's broken is not the idea that the candidate with the most votes wins and my elector isn't a Republican every time, or I don't feel like I'm represented in the electoral college. You know, it's because I'm very comfortable losing elections and getting organized to win the next one. You know what I mean? Like it just means that I have to take my message in the most direct way to the most voters, and it needs to resonate, right? And at the end of the day, in a republic, these body of governments are supposed to reflect the voice of the people, right? So, you know, rejiggering, you know, everybody feeling good. I mean, nobody's ever going to feel good about the outcome of an election where their candidate lost, but we can all get better at living with the results if we just follow this time-tested principle in every other election we have, which is that the candidate with the most votes won, right? And that's clearly defined. And so, you know, that's where I think, you know, there's a whole bunch of democracy reform going on, right? And don't get me wrong, I think everybody's reform is important to them, right? Everybody else's reform isn't you know what I'm saying? But like the one single reform that will do the most good is to reinforce this idea that the candidate who gets the most votes is going to win the election, and that we can all get better with living with that result. It's probably going to affect the ecosystem more than just about any other conversation we're having or talking about.
That's true.
That's kind of what I'd put out there for the good of the order. Loving, you know, a lot of people, a lot of allies on my issue that are ranked choice voting people, you know what I mean? Love all the work that everybody's doing. But at the end of the day, you know, you want to have the simplest, most meaningful reform that's going to improve the entire ecosystem that is American politics. Why don't we just reinforce this idea? Candidate with the most votes wins. You're a voter. You should matter. If you lose, get organized to win the next time. But let's all get busy living with the results, right?
Beautiful kind of sentiment.
Is that our conclusion, folks?